Thank you for joining us for our fifth webinar in our annual Conn Maciel Carey Employment Webinar series. We have webinars just about every month, and we invite you to check out our other webinars that are listed on our website. But this subject is near and dear to us. It's a subject that doesn't get far enough attention in HR and employment law circles. And the subject for today is Sommer loving, managing relationships in the workplace, nepotism, and other interpersonal issues. And it's interesting, the topic is Sommer loving, and we happen to be based in San Francisco, the city of the Summer of Love. But we wanted to discuss some of these really key subjects touching on managing workplace relationships. And my name is Andrew Sommer, partner with our California office, and I'm joined here by my colleague Megan Shiked, who is also a employment law attorney in California. And so for today, we're going to discuss some practical considerations to keep in mind when managing relationships in the workplace, whether it be a romantic relationship, dating or marriage, or whether it be simply a familial relationship that could have a potential adverse impact on the workplace. And so we will discuss some of the legal issues, particularly around harassment and privacy rights, as well as getting into some of the nuts and bolts of how this can be managed from an HR perspective. So I wanted to first just very briefly introduce myself. I am, again, Andrew Sommer. I have over 20 years experience as an employment litigator defending individual as well as collective actions both in state and federal court. And the types of cases I've handled over the years have involved wage and hour, leave of absence issues, as well as, of course, harassment concerns, and whether that come up in lawsuits involving supervisors accused of harassing subordinates or coworkers and various different permeations of that. We also, I as well as Megan, we have a robust counseling practice advising employers on handling a variety of personnel matters, including the handling of harassment investigations and what actions to take as a result of those investigations. And now I will turn it over to Megan to introduce herself.
Thanks, Andrew. Hi, everyone. As Andrew said, I'm Megan Shiked. I'm an associate at Conn Maciel Carey. I practice in both the Labor and Employment Group and the Workplace Safety Group. As Andrew does, I represent employers in litigation, federal and state court, handle all sorts of claims, including claims of discrimination and harassment, which we'll be talking about today, wrongful termination, and wage and hour cases as well. And then on the counseling side, I've definitely been kept busy these days conducting workplace harassment trainings and counseling employers on terminations, hirings, wage and hour compliance, and the development of good policies and handbooks.
All right, so wanted to discuss the agenda for today. We're going to cover workplace relationships, again, whether that be simply familial or romantic relationship, and what is at stake. Specifically, what are the legal ramifications of having these workplace relationships, particularly in light of the Me Too movement and harassment concerns, as well as privacy rights, and then very kind of practical considerations that many businesses are taking into account, whether that be morale, a perception of fairness, employee retention, protecting the company's reputation, all considerations impacting how you manage workplace relationships. We will also discuss the different types of claims that can emanate from these types of relationships, and that can be discrimination claims, harassment claims, retaliation claims. We'll also cover the pros and cons of policies regulating workplace relationships, whether that be a policy barring those involved in an intimate relationship from having any kind of supervisory authority over one another, or perhaps having a policy that's much broader, just prohibiting any sort of romantic relationship among employees working together. We'll also address steps employers can take to manage risks associated with workplace relationships, and that can take a variety of different forms. Megan will be covering the issue of a love contract. It's a kind of a funny term. And we'll also discuss the policies and procedures that you can have in place, also whether to have any sort of HR oversight when there is knowledge of a romantic relationship, or maybe even just any regular family relationship, and have a heightened awareness of the impact that that could have. So now I'm going to turn it over to Megan to start off the discussion here.
Thanks, Andrew. So at the outset, I just wanted to get out there that we recognize different people and different workplaces have varying levels of acceptance and comfort with workplace relationships. And we want you to keep that in mind as we're having our discussion today, because some of these issues, there's not always a clear-cut answer on what to do, and the right answer for you is really going to depend on the details of what your workplace looks like, what business you're in, who you're dealing with, and kind of the makeup of your employees. The point is to recognize that workplace relationships happen, and this is why we wanted to go over some of these statistics, and there are lots of numbers floating out there, but these ones in particular are taken from a 2018 survey from CareerBuilder. And another thing to keep in mind is that these numbers are coming from after the height of the Me Too movement. And even as of that date, 36% of workers reported dating a coworker. So these numbers are pretty high, and 22% of workers reported dating someone who was their boss at the time. The number gets even higher if you ask whether workers were dating someone at a higher level in their organization than they were. So not necessarily their boss, but somebody who maybe outranked them. One piece of maybe good news, if you consider it that, is that 31% of workers reported that when they dated at work, it resulted in marriage. And the other side of the coin is 24% had reported that they had an affair with a colleague where one person in the relationship was married at the time. Another statistics that we pulled out, which was, it may seem like a low number, this 6% of workers left a job because of a romantic relationship, but when you look down into the details of the number, it was actually a little bit higher for female workers than it was for male workers. It was closer to 10% would leave a job because of a romantic relationship. And 41% of workers kept their romances secret. And these will all play into some of the things that we'll talk about later on in the webinar, but the idea of workplace romances being a secret makes it particularly difficult from an HR standpoint, and we'll get into that again later. So again, the point here is to recognize that workplace relationships happen, and your goal as an employer is to think through what your policy should be and how you can manage the risks involved. So with a title like Summer Loving, we had a fun title for the webinar, but the reality is that this is a serious topic, and both employees and business owners have a lot riding on the success of their work life. So inappropriate relationships at the workplace, again, whether they're romantic or familial or otherwise, can have a negative impact on everyone's bottom line. Harassment, it cuts against the meritocratic environment where people are getting ahead because they're doing really good work. And this can really alter employees' motivation to be productive. It can alter employees' motivation to stay with a company. And it can demoralize the entire work environment, cut into morale, and is contrary to the shared value that we should all be striving for of equal opportunity. Harassment can damage business and personal reputations, and with the potential risk of liability for employers and individual employees in certain circumstances, everyone's bottom line, not just the company's bottom line, is at risk. Even the lawyers, even I am willing to admit that it's not all bad. It is possible to have healthy workplace relationships and maintain a professional environment free of harassment. But that can be very difficult, and it can be incredibly tricky when there are workplace romances happening. So there can be happy employees come out of good, healthy relationships, right? You can have lower turnover, which in turn can protect the institutional memory of an organization. And happy, loyal employees can stay with the company and help protect confidential information. But again, the reality is that workplace romances and workplace relationships of all kinds can be tricky, and they bring a host of issues that can involve not only the people in the relationship, but those outside of it. And of course, not all workplace romances end badly, but some do. And things can start to go awry in many different ways. Workplace romances can lead to others outside of the relationship being concerned about favoritism or conflicts of interest, and these can be perceived or real, and it's something to pay close attention to. We can all imagine a situation where an employee seems to be getting a coveted schedule or other important opportunities, and people start to notice. And when there's a workplace relationship going on, people may start to question the merits of that coveted schedule or wonderful opportunities. And if things start to devolve to office gossip or distracted workplace, and employees start having hurt feelings or resentment towards their coworkers or superiors or the organization in general, then you can start to have real problems. And of course, the worst case scenario is claims of discrimination, harassment, and retaliation, which can get incredibly ugly. To give you a very extreme example, but it happened nonetheless, we had a case that went to the Supreme Court in California involving a male prison warden who was known for having affairs with female corrections officers. And it became a problem. The obvious is that he was having these relationships with multiple female corrections officers, and it was not only blocking female correctional officers who were not engaged in relationships with him were blocked from merit-based advancement. So you had a hostile work environment, sexual harassment claim against the prison warden for these relationships. But another associated problem is that you also had at least one of the girlfriends of the prison warden, who was a coworker of these other correctional officers, was harassing the women who weren't the warden's girlfriend. So you had harassment, and you had harassment by the girlfriends, and you had harassment by the prison warden. And it's just bad all around. When you get to litigation, and some of these remedies may differ depending on the state that you are operating in, but the remedies for an unlawful harassment case for the company is going to be the attorney's fees, and this is not only the company's attorney's fees for having to defend the case, but also paying the attorney's fees of the prevailing plaintiff if they were to win. There's compensation and punitive damages to the plaintiff. Sometimes there can be reinstatement of the employment and lost wages, both the wages that may not have been given as the employee was working, and wages that they may have lost out on if they were, say, terminated wrongfully. And then for the manager, the individual harasser, there can also be liability that's similar to the company. And depending, again, in the state where you're operating, there may be additional tort liability if the alleged harasser, the harasser, had incidents of assault or defamation or other claims that would allow a plaintiff to recover against the harasser individually. I'm going to take a step back now and provide a little bit more background on some of the legal claims that can play into these tricky workplace relationships. So we have discrimination, harassment, and retaliation. And we want to provide a little bit of context as to why workplace relationships can present such a risk for these claims in particular. So under federal and state laws, there's a prohibition against discrimination and harassment based on a variety of protected characteristics. And these differ a little bit depending on if you're at the federal or the state level. So I've highlighted sex and marital status because we're going to talk quite a bit about that today. But just note that discrimination and harassment can be based on any number of protected characteristics. And the ones that are often protected under state rather than federal law are sexual orientation, gender identity and expression, and marital status. So for those, it's going to be dependent on the state in which you're operating. And how we often see sex-based discrimination in workplace relationships is where someone is treated unfavorably because of that person's sex. So for example, discrimination can occur when an employee can only advance in their career by engaging in a relationship with a superior. And recently we've had a little bit of an unintended pushback from the Me Too movement, where we've also seen discrimination can arise where, let's say, for example, a male manager is in fear of being caught up in a harassment case, shies away, whether intentionally or unintentionally, shies away from opportunities to mentor female colleagues. We can have a situation where, in an effort to avoid a harassment case, an employee walks themselves into a discrimination case. So it's really important to think about how these things may play out, and you'll see here on the slide that they can play out in terms of hiring, firing, an employee's compensation, job assignments, especially if some job assignments are going to give you opportunities to advance in your career. Of course, promotions. Terminations is a issue that comes up quite often, and there are other terms and conditions of the employment where we can see discrimination at play. I did highlight marital status in our first discrimination slide, and it's inevitable when we give presentations like this that sometimes people throw up their hands and say, well, there's so much that I can't do. What can I do to make this better? Well, the answer is there's a lot, and we want to give you a little bit of a preview of things that you can do to maintain a professional workplace, even in the face of tricky workplace relationships. So most states do protect against discrimination based on marital status, as I mentioned, but this doesn't necessarily limit your ability to regulate the work environment. So just as an example, under anti-discrimination laws in California, an employee is still allowed to regulate the working environment and is allowed to regulate, for example, the working of spouses in the same department. And this is for purposes of business reasons, of supervision, security, and morale. So this is a recognition that it may be a conflict for a wife in a small location to be supervising her husband. And this allows employers to do something about that. Another recognition of this is that that employers can decide not to place both spouses in the same location under the direct supervision of one another. And if employees who are not married to begin with get married, it also allows an employer to make efforts to assign job duties so that you're minimizing problems that might arise from supervision or other potential conflicts of interest. Another note, we talk a lot about workplace relationships in terms of romantic relationships, but as Andrew mentioned, there's also the issue of familial relationships. And the thing to think about here is that it's not family relationships do not necessarily present a problem, but you do want to keep in mind that some of the same risks that exist with romantic relationships, the risk of potential or perceived conflicts of interest or favoritism or even discrimination, can crop up in familial relationships. You could think of a situation where a seemingly benign situation, like a family organization, a family business that's been in operation for decades, may, depending on the circumstances, have a situation where protected status like race or religion or national origin may crop up just because of the nature of the makeup of the family. So the key here is to, as we'll talk about later on, is really to be aware of this issue, and it's really important to have clear policies and then to apply those policies consistently. So for example, you don't want to allow the boss's family member who got hired to be treated harsher or less harshly than all other employees. So this is where this comes into play and what we want to pay particular attention to. So now that I've covered some of the background on discrimination, I'll hand it over to Andrew to talk a little bit more about harassment and retaliation.
Thank you, Megan. And I will just to follow up on the familial relationships. One issue, of course, is typically when you have a romantic relationship, it's husband and wife or a couple that's dating, you can have a sexual harassment component there that creates obvious concerns and a question of favoritism. With a familial relationship where you don't have a romantic relationship, a marriage, it could be a father and daughter that are in the workplace, the concern is it typically could arise. I mean, you think about there's typically no law that would directly impact that relationship and conveying favors, for example, there to the daughter of the owner of the business. But where it could come up, as Megan alluded to, is if you have a situation where the family that owns the business all have a religious faith that's salient, and that there may be certain favors, recognition extended to employees that are of the same religious faith, and that could subject you to a religious discrimination claim. Or you could have a situation where the family is all of a certain national origin or of a race, and there could be a perception based on favoritism towards the family members that you have to be of the same national origin or race to advance within the company. It's highly factually specific, but of course, if it is a family-owned business, there's going to be some difference in treatment to the family members, but just something to be aware of. So we wanted to next move into the framework for harassment. And just so you understand how this might play out if there were a harassment lawsuit. And just very generally, harassment can take a variety of forms. It could be verbal, nonverbal, or physical conduct, but it must be first unwelcome conduct. And that's a really difficult legal term of art to unpackage, but essentially unwelcome doesn't mean that the employee, that it has to be not involuntary, but rather the test is whether it's conduct that's desired. And so you're really, in a way, getting in the head of the victim of the harassment. And really where this unwelcome component is challenging in the context of our talk today is where you have a situation in which two individuals are dating, for example, and it could be, say you have the situation where you have a supervisor and a subordinate dating. Initially, the relationship may be something voluntary, where you have the subordinate is willingly participating in the relationship, but over time, he or she is no longer a willing participant and may be trying to extricate him or herself from this relationship. Or they may be conduct in the workplace of a sexual nature that initially is found entertaining, not problematic, but over time becomes something that is not viewed as acceptable by the subject, and that could be viewed as a hostile work environment. The other components here is that the conduct has to be harmful to the physical and employment health of the victims at issue, the witnesses. It must negatively affect the workplace, which oftentimes is not that much of a hurdle to establish. And it's important to note that men and women on every level may be considered harassers or victims. The typical scenario that comes up in legal cases involves a man harassing a woman, but there can be women harassing men. It can be individuals of the same sex that could be the harasser and the victim. And so what are the different permeations of harassment? You have, and I've seen over the years in legal cases, I've seen this every which way. I've seen cases where you have a supervisor that's in a romantic relationship with a subordinate, where there's a claim later on that it's not consensual and that this is harassment. There can just be conduct by a supervisor against a subordinate that's viewed as boorish behavior that leads to a harassment claim. You can also have peers. You can have coworkers working side by side or in different departments where there's a claim of harassment based on certain conduct that occurs, and typically that's more of a hostile work environment where there's an allegation of abusive conduct. And lastly, this doesn't get enough attention, but there can be harassment that's perpetrated by a third party that's not an employee of the company. And that's something to really have on your radar. And you can have the situation where you have a delivery person who's making unseemly comments towards an employee. You could also have clients or customers, anyone else coming onto the workplace. That's something that the business should be aware of. But I wanted to break down the two different types of theories of harassment. And you can have conduct that gives rise to a claim of harassment under either theory. And many of you are aware of this if you've been trained on sexual harassment, whether it be as an HR employment counsel or just a manager. But it's important to understand the framework here. Quid pro quo essentially means this for that you're extending, you're giving one thing in exchange for getting another. And then hostile work environment, that's a term of art. At this point, employees are pretty savvy on this term, and you might find that in the workplace that you have an employee that comes forward and says, I'm subject to a hostile work environment. And they do that as, it can be done in good faith. It could also be as a form of intimidation to get you to take notice because it's such a charged term. But hostile work environment has a very specific definition that we'll cover. But I wanted to first address quid pro quo. And that's really a situation that's particularly relevant here to the discussion of workplace romances. A quid pro quo is essentially the situation where there is a supervisor. Quid pro quo involves the dynamic between a supervisor and a subordinate. And it addresses the situation where a supervisor conditions certain positive outcomes in the employment to some sort of sexual activity. So it can be the supervisor stating to the subordinate, A it can either be directly stated or implied, but it can be something to the effect of, you go out on a date with me and I'll see what I can do about that promotion you've been seeking. Or, hey, you want to go on a date and we can talk about the raise that you've been asking for. It can be more overt, go to bed with me and I'll see what I can do about your employment. It can be very subtle. It can be extremely direct. And the type of positive outcomes that are essentially negotiated here can be a good performance review. It can be a better work assignment, a pay raise, a job promotion, retention of the position. And the employee typically needs to suffer some sort of monetary loss or change in work assignments. So, there are cases addressing this situation, and where there is, and this is where I'm going to tailor this to our discussion today, is that if you have a relationship that's consensual and a judge would conclude that this is welcome conduct, you could still have some exposure under the harassment laws, and that would largely depend on if there's widespread granting of favors in this situation, or if it's isolated to a single relationship. And the courts come down in a variety of different ways. It's something that you need to be sensitive to. But if you have an individual that's dating one person or married to one person, and it's isolated to that, a court's probably less likely to find that if it's determined that the relationship is consensual, that this is creating any sort of quid pro quo or hostile work environment dynamic. However, if it's widespread, like the case that Megan was discussing previously, where there's a supervisor having a relationship with different employees and each time granting some sort of favor in exchange, that basically sends a message, arguably, to the whole workforce that if you want to get ahead, you need to have sex with your boss. And that's more likely to lead to a finding of unlawful harassment under quid pro quo. And it's important to note that threats that are made, you have to have sex with me in exchange for job benefits, even if there's no adverse employment outcome, it may still lead to a hostile work environment. And so I wanted to discuss that now. And hostile work environment, it's a term everyone uses, but not everyone understands it. And the difference between a quid pro quo and a hostile work environment in the context of our discussion today with romantic relationships is really that you could have a, as I mentioned previously, widespread offers or conditioning of employment on sexual favors that suggest that that's what you need to do to get ahead, and that could lead to a quid pro quo claim. But it could also create just an overall demeaning atmosphere for women. As one example, and that could be seen as an overall hostile work environment. And so again, you have to show that the conduct in the workplace that's the subject of the claim is unwelcome. It has to be aimed at the person's protected status. So if it's just boorish behavior, it has to be related to someone being their gender, their marital status, any other protected status. Here, in our context, it would really be related to someone, sexual conduct of a specific nature, someone's gender. And the conduct must be severe or pervasive, and that means that it has to alter the conditions of the employment and create an abusive work environment. And how that works is severe just means that it's onerous, that it's significant. So if someone touches someone's body in a inappropriate way, just doing that once could be seen as significant enough that that could give rise to a harassment claim. But if it's not severe, it could be one comment, say babe or honey, that's said once that would be seen as inappropriate, but maybe stating it once would not be enough to give rise to a claim for unlawful harassment. In, in that scenario, for it to be an actionable claim, you'd have to show that it's pervasive, meaning that there's a pattern of conduct that would be sufficient in that situation to then rise to the level of an abusive work environment, a hostile work environment. So some examples of problematic behavior. We talked, of course, about the demand of sexual favors in exchange for job benefits, but it can also give rise in physical conduct. It could be touching someone. There could be nonverbal conduct that can be more challenging to identify. It can be inappropriate staring at an individual. It can be leering, winking, obscene gestures, various different graphic images that are conveyed by email or visually in the workplace or otherwise. There can also be verbal conduct that's often can be telling off-color jokes, use of profanity, potentially derogatory names, insults, jokes, and that might not be seen as sexual harassment, but it could be seen as another form of harassment, perhaps based on race or other characteristics if those slurs or insults can relate to that protected status. Comments about person's body or looks is also something that can come up and be seen as harassment. There's threats, references to popular culture in a way that's inappropriate. So, one important note is that harassment is actionable against an employer if it occurs in the course of the employment. And so what's in the course of the employment? So if you're in the workplace, someone engages in inappropriate behavior, whether it be a demand for sexual favors or other inappropriate sexually harassing behavior, in the workplace, that's something that can be the basis for a lawsuit. But then there's all these other areas where it's really more tenuous and a lot grayer. And so you have a situation where you are traveling on company business. That would be considered in the course of employment. Definitely business travel, after-hour meetings that are work-related, company-sponsored events. You could have your holiday party. To me, that would clearly be in the course of employment. But what about social events? And that's really the struggle. Is you can have a situation. I've seen this come up many times, where you have coworkers go out for drinks, and then something inappropriate occurs there. Is that something that could be the basis for a lawsuit? Of course, the obvious concern is that this could come back to haunt you in the workplace, because they're going to remember this incident. It's going to come back. It'll be a source of discussion in the workplace. Given various state privacy laws and other protections, you have to be careful and consider your state in regulating conduct that occurs outside of the workplace. But certainly, if it's a social event that is sponsored by the business, whether it be directly or indirectly, if there are supervisors at the meeting, that could certainly be considered a work-related function. You could have legal exposure for what occurs there. And so one really important point is that you need to provide training to your supervisors to make it clear the parameters and if they are attending social functions off the clock with subordinates and the potential legal ramifications. In doing so, they essentially become the eyes and ears of the company and can create liability for you. So harassment concerns just very generally in the workplace. Any overly familiar working relationship, whether that be romantic, can be a problem for you both in establishing morale and a positive work environment, also legally. And this can come up in a variety of different ways. It could be, someone just calling their significant other honey in the workplace, and that can make other employees uncomfortable. It could relate to a complaint from employees to HR or otherwise. It could also be, very just practically, if you have a husband and wife or a couple that's dating and they start bickering in the workplace, that's definitely going to be a huge negative for those that have to work with them. If you have someone caressing the shoulder of their significant other in the workplace, that could also lead to a very uncomfortable work environment for everyone involved. And then you have the situation, as we discussed, of the perception that, or actual or the perception that individuals are receiving benefits or favors for having a relationship with the boss. And there can be situations where the relationship is not disclosed, or it is disclosed, and there's a perception by other subordinates that they are not benefiting like the individual that's having a relationship with the boss. And that's particularly an area that requires heightened sensitivity by HR to avoid any legal exposure and poor morale. And again, it's just the perception that the way to advance is to have a relationship with the boss, and that's something that needs to be have heightened awareness. And then want to discuss rather briefly retaliation concerns, and these come up in essentially any scenario where you have a complaint of harassment. And here you could have an employee complaining about the boss having a relationship with a subordinate or coworkers dating and the effect it's having on the workplace. And once they make that complaint, they become sort of a walking retaliation claim potentially, and you need to have some concern about avoiding any claim of retaliation. So if you have a subordinate of the boss who's alleged to have had this inappropriate relationship with a subordinate, since that boss has supervisory authority over the subordinate that's now complained, that individual also has the authority to retaliate and take adverse action against the individual for making that complaint. So it's really important in those situations when there's a complaint made to make clear to the complaining person that they are protected against retaliation. You have a zero tolerance retaliation policy, non-retaliation policy, and that be conveyed as well to the subject of the complaint who has the ability to retaliate. The forms of retaliation can be very simple. It could just be a negative performance review that falls on the heels of the complaint. It could be a denial of a promotion, termination. It's very challenging from a management HR standpoint to address concerns about retaliation, since of course once someone makes a complaint, it just creates an uncomfortable environment for the persons that are the subject of the complaint and how to navigate that. Hard feelings are almost inevitable when there's a complaint made, and you could have a situation where the relationship is not so good between the person complaining and the alleged harasser, and then it just goes from bad to worse after that. And as I alluded to, the power to harass is also the power to retaliate. If you're a supervisor that has authority over a subordinate, you have control over the working conditions of that individual such that there could be a claim of retaliation. And the key here is to recognize the potential for retaliation and give employees confidence and reaffirm that it is an important concern that there be no retaliation in light of the complaint. And The issue that comes up often in harassment cases is, why did the victim of the harassment not complain? And it's pretty easy to say, from a defense standpoint for the employer, like, this individual did not complain, therefore the harassment did not occur. And the difficulty that's encountered is there's lots of reasons legitimately for someone not to complain. They might not complain because they don't want to get in trouble. They want to fit in. It might be awkward to talk about things of a sexual nature. And they might want to, particularly in certain workplaces where you have teams that work together, there may be a concern about the morale and what impact that would have if there is a complaint made, and the fear of retaliation. And the concern that comes up with romantic relationships, it's particularly between a subordinate and a manager, is that if it can be a consensual relationship at the outset, but over time it might no longer be consensual. It might be that the subordinate is trying to end the relationship, and there's some conflict over that. And so if it is a relationship that is not known within the company, there may be a reason not to not discuss the relationship because of concern that they are violating company policy by not disclosing the relationship, and they fear that they'll be fired for doing so, so they might keep it all under cover and the whole time be finding the relationship to be unwelcome, not desirable. And the other situation is it could be a known relationship, but it could be a great relationship. It could be husband and wife even, and all of a sudden, there's a conflict. Things are not going well, and they don't want to discuss the relationship for personal reasons with the company, but there might be a lot of conflict that is directly impacting the work environment and could potentially open you up to a harassment claim. So what can you do to address these concerns? It is important to have a clearly developed, rigorous anti-harassment policy and provide training. Many states require training of supervisors, and California just augmented that requirement to require training of non-supervisory employees. Even if your state doesn't require training of supervisors, it's highly encouraged given the exposure that you have for the conduct of supervisors. And we would recommend including a policy on dating within that harassment policy, and that many companies will have a policy that will state at a minimum that if you are in a romantic relationship with someone at work, you cannot have any supervisory authority one over the other for obvious reasons. And some companies go a little further and just say you cannot have a relationship with someone in your department, and those are things that you need to assess, really considering the laws of the state where you operate. Your policy should make it really clear what the avenues are for complaining, open door policy, conduct harassment training for employees in addition to supervisors. That's encouraged if that is an option for you. And then it's really important that managers and HR have a heightened sensitivity to this problem. If there is a romantic relationship going on, if someone's dating someone else, as you become aware of it, you address it consistent with your policies and procedures. If there is an accepted romantic relationship in the workplace, how to navigate that in light of any concerns over fairness, favoritism. And really the key thing typically in any situation like this is to have this heightened sensitivity and to react immediately when these high hazard situations come to light. All right, so I'm going to turn it over to Megan to discuss anti-harassment training.
Thanks, Andrew. We wanted to make a few additional notes about anti-harassment training. As Andrew mentioned, this is really important and required by many states. We have seen in the aftermath of the Me Too movement, we've seen states adding or expanding their existing training requirements. There's really been a push in anti-harassment legislation, and it's important to pay attention to this to see if perhaps you think you're doing the training according to your state requirements, but you'll want to note if there's been a change, if you need to start training a wider group of employees. In California, the training requirements, like Andrew mentioned, have expanded to include not only managers, but all employees in workplaces of a certain size. There can be training tailored to managers versus non-managers, and you can really get into the details and explain to the employees what's involved. You'd be surprised how often we get calls about harassment complaints where the people involved really didn't know that what they were doing was considered harassment. And so it's really important to take these training requirements or considerations as an opportunity and have the conversations, the difficult conversations with your workforce, and make sure that the expectation is clear. The policy, it's important that you have a written policy. The anti-harassment training is a really good time to distribute that policy and go over it and make sure there are no questions about it. You can certainly train employees in the absence of a requirement to do so. Before there was the institution of the requirement in California to train non-managers, some employers decided they wanted to do employee-wide training for everyone, and then they would train their supervisors separately because it was that important to the organization, and they wanted to make sure that everybody was on the same page. Another thing you can do that's a good practice is to redistribute your anti-harassment policy on a regular basis, annually, or in some way that makes sense. Training requirements differ from the state in terms of how frequently they must occur, but there's nothing stopping you from reminding employees of your anti-harassment policy. So we've mentioned these anti-fraternization or no dating policies and how it's a good idea to consider having them. If you already have it or you consider adding it, it's a good idea to place it near the anti-harassment policy if you have that in your handbook. The reason is sometimes handbooks can include quite a bit of detail and different policies, and you want it to be very clear to employees how the anti-harassment policy and the no dating policy may work together. And you also want to go through the exercise of thinking that through and what that means for your organization. A no dating policy can take many forms. You can have an outright ban, although depending on where your business is operating, you want to be mindful of restrictions that may exist. For example, privacy restrictions that, like Andrew alluded to, restrict an employer's ability to regulate behavior outside of the workplace. But certainly bans on relationships between supervisors and direct reports are a good idea and are our most frequently seen no dating policy. You can also have restrictions for employees dating in different ranks, even when they are not directly supervising one another. Again, depending on the nature of your business, you may have a specific concern with employees having relationships with a client or a vendor or some other third party that they are working very closely with. Or unrelated, it may just bring up a good reminder to have a robust policy for not sharing confidential information, as that is sometimes the impetus for a no dating policy between employees and third parties. So you may want to consider, well, maybe the concern can be easily addressed by reminding everybody of our confidentiality policy rather than having a dating restriction that doesn't make sense or is in violation of other privacy policies or restrictions under your state's law. And then sometimes, we see no dating policies for employees staffed on the same project if it brings together employees from various parts of the company who may not usually work together. So these no dating policies can be helpful because they do set a clear expectation. They are an opportunity to communicate with your employees and set a standard, and it can protect against unwelcome behavior. It's another opportunity to say, hey, these relationships can be really tricky, and we would rather maintain a professional working environment, and here are the ways that we're going to do that. They can also be counterproductive to the extent that employees who are in a relationship are going to be in a relationship regardless of a policy. Then you can be in a situation where you need to discipline employees who have violated a company policy. And you have to be prepared, if you have a policy in place, to apply that policy consistently. And it can also discourage open communication and in some cases lead to people keeping their workplace relationships secret, which can then cause other issues if the relationship were to devolve. So whether you have an anti-dating policy or not, and what that looks like, you really want to have some soul searching about what makes sense in your organization and how much oversight you want to have from HR. Another common policy you may have heard about and we see are quote-unquote love contracts. These are essentially consensual relationship contracts where both parties in the romantic relationship state to the employers that they are in a relationship, that the relationship is voluntary and consensual, and that they are aware of the employer's sexual harassment policy. This can encourage open communication. It can send the message to the employees that, hey, we recognize this is a reality, and but we also want to combat the risks associated with it. So please just come forward and let's talk about it. It also gives you an opportunity to speak to the people in the relationship and the workforce at large and help identify problems that may arise. For example, if a voluntary consensual relationship falls apart and is no longer consensual, or an opportunity to remind employees that there may be a problem with relationships where there's a power dynamic, especially if you have one member of the relationship in a higher rank in the organization, that there may be pressure to engage in that relationship, and so having an opportunity to have a conversation about what is consensual is important. Of course, the downside of love contracts, this is what can make them really counterproductive and problematic in some circumstances, is that it does insert the company in the middle of the relationship. That may happen regardless of whether love contracts are on the table, and HR may have to play a role in paying attention to whether workplace relationships are occurring and whether or not they are going awry. But certainly if you institute a consensual relationship contract, you are signing up for being involved in these relationships. And like I said, it doesn't prevent person from the relationship from claiming that the relationship was not consensual, or that even within a consensual relationship it does not prevent claims of harassment. It certainly does not prevent claims from outside of the relationship if there continues to be perceived or real issues of favoritism or conflicts of interest, or even harassment and discrimination.
And I was going
to
whether
add
or not just a couple. Oh, Megan, I was going to add a couple points here. Is that so? Megan makes really good points here. Is that you can't just because there's a couple signing this so-called love contract, that doesn't mean that it's consensual at that time, or that it doesn't become unwelcome at some point later. And then it's just, from my vantage point, I've seen these love contracts over the years, and I find them incredibly awkward. That you're really getting into the relationship of the couple, and so there may be employees that do not come forward because they don't want to have to get into this discussion and sign any sort of love contract. And it could be seen as some sort of invasion of privacy by the employees involved. And so if you're going to, even if you're going to ask for the love contract, that doesn't mean you shouldn't engage in other measures such as reassigning the supervisor potentially as one option, so that there's no reporting relationship between the supervisor and the subordinate, or other measures that can be taken. Just because the love contract is signed doesn't mean all your problems are resolved.
And piggybacking that, piggybacking what Andrew just said, you can also include additional details in either a anti-harassment policy or a no dating policy, or just a dating policy in general, that certain behaviors are not appropriate. For example, explicitly saying no public displays of affection. You may have a consensual, healthy, non-distracting relationship among spouses in the workplace, but maybe not everybody in the workplace needs to see you hugging or kissing or bickering, like Andrew said, about home life. The other thing I already mentioned, it's often a good idea to put these policies close to your anti-harassment policy in the handbook. But it's also good whether or not you have a no dating policy or require love contracts, that you're really clear about your communication, that you communicate very clearly your expectations of the employees. And this gives an opportunity. You don't want to let an opportunity go by without telling the employees, what the problems are that can arise in these tricky workplace relationships, and what to do when they do go awry, how to report complaints. And then you want, as an organization, that you be prepared to handle complaints and handle potential investigation that might come from any complaints. And Andrew may have additional comments to add to that.
Yeah. There was a question I wanted to answer, but one point that I don't think we really got into was, you can have a situation where you have a supervisor and subordinate that have had a relationship. Say that relationship started before they joined your employment, but you could have other situations where, which is probably the most common, where you have a subordinate that is being directly supervised by the manager, and they develop a romantic relationship. And the problem that arises there, and I think your policies need to be really clear on this point, is that supervisor should not be starting a relationship with a subordinate, for the obvious reason that there's a power imbalance. And there's a question about motives for starting out the relationship. And so I think the policy should always make clear that there should be no romantic relationship between a supervisor and a subordinate. But then the question next is, if it does arise nonetheless, you could then develop some mechanism for addressing it. And that could be, and there's a variety of different options, but one could just be that you reassign the supervisor to a different team so that there's no reporting relationship at that time. And that's the minimum that I would recommend. But there was a question that was, can the employer legally say you can't date? And that, again, is going to depend on the state in which you operate. In California, there are some potential concerns based on protections under California law prohibiting an employer from regulating conduct that occurs outside of the workplace that would make it challenging to have such a broad prohibition. But what I would recommend is one option in California would be to, there's two things. You make clear that the supervisor and subordinate that are dating cannot be in a supervisory relationship. Another option, depending on the dynamic, would be to not allow the two individuals to be on the same work team. They have to be on separate teams. But just prohibiting them from dating altogether could present some legal challenges. But again, that depends on the state in which you operate. And there was another question. Can employer be sued by employee based on two other employees being in a relationship? So I'm not sure I'm following that question. If it's a coworker, yeah, I think I would need more details to be able to answer that. But I did, we are available offline. You can reach out to us if you have any questions or want to talk further. And we will distribute a set of slides with a link to the recording. And I wanted to thank you all for joining the webinar today. Thank you all for attending.